Uh, the presentation that I thought I'd do this morning is related to at-will employment, sort of generally, and its exceptions. Now, this is something that sort of fell out of, so last Township Tuesday, we were doing drug testing and its implications for townships, some of the modifications that had been made to the act. So I thought, it might be good to kind of back off a little bit and start getting a 10,000 foot picture of our townships as employers and what sort of limitations there are on those traditional doctrines. Now, this is kind of the big one. This is the one that sort of organizes employment law as a whole. And it is this doctrine of at-will employment. So the traditional rule, going back to time out of mind, is that an employer can fire somebody for a good reason, bad reason, or no reason at all. That's stated most recently in Martins versus Minnesota Mining and Manufacturing Company. But this is something you'll see throughout kind of the case law, just as sort of the default rule against which cases potentially get measured. Here, I think it's worth bringing up the historical context that this doctrine developed in a time where there was not a whole lot of difference in terms of negotiating position between employees and employers. This sort of the original idea is that there is this sort of equality between the two. That is, that both the employer and the employee have the right to terminate the relationship at any time for any reason. This started to get happened or attenuated over time because particularly by the early 20th century, what we started to see were these gigantic institutions that were sort of operating nationwide, and they were requiring particularly specialized employees. So where once upon a time negotiating power certainly wasn't equal, but it was more equal. Now that is becoming less true over time. And so Congress and the Minnesota State Legislature decided to start limiting this doctrine. So while this remains in Minnesota the default rule, there are many exceptions to it. The first exceptions that sort of developed were statutory. The earliest was for union activity. You can't be fired for union activity, and that comes from the National Labor Relations Act. And then this was followed by a wave of anti-discrimination statutes. So, the originals were age, race, religion, disability, or gender, and those were added. To those were added things like disability status, the national origin, things of that nature. So that is kind of the big picture overview of those. There are certain purposes for which you cannot discipline or fire an employee, and those have been expressed in statute. And that's not the only way that these things have been limited. In Minnesota, particularly, a fairly, important era in jurisprudence was the 1980s. This is when Minnesota courts began creating common law exceptions to this doctrine of at-will employment. Common law, of course, being sort of judge-created or judge-made law. These new judicial exceptions can be divided, broadly speaking, into three categories. There's the contractual theory of limitation on discharge, there's the tort theory, and then there's the public policy theory. And we'll just kind of go through these briefly, kind of a 10,000 foot picture. And, if there's interest, we can certainly go into this in more depth in a future potential presentation. But so here's the big one. And this one is sort of originally developed from union activity, but it's not limited to that. And it's a contract. So Minnesota continues to recognize the doctrine of at-will employment as the presumptive nature of any employment relationship. Hire me for without more information or without more sort of to go on. A court is going to presume that we've got this original rule in place. That is, you can fire me for good reason, bad reason, no reason at all. Aside from, of course, our statutory limitations. But there is this additional one. As with many things, an employer and the employee can mutually agree not to follow this doctrine if they want to. Now, significantly, particularly for townships, this doesn't have to look like the township and myself sitting down to have a negotiation and to sign a document calling itself a contract. The big limitation here, or the one that townships will often accidentally get in trouble with, is employer handbooks. Now, this one comes from a case called Pine River State Bank versus Melilele. This is a 1983 case. And in this case, the employer, that is the bank, had distributed a handbook containing an explanation of its disciplinary procedures that were to be applicable to all employees. It then discharged an employee, a loan officer, for several deficient loan arrangement without following the handbook's procedures. So the Minnesota Supreme Court ends up saying that, no, this wasn't okay. Your employer or employee handbook in this case amounted to a contract because you didn't specifically disclaim that. And they give us 4 elements for determining whether or not a handbook can become a contract. So it's an offer which is sufficiently definite and specific and not merely a general statement of policy. So you can potentially limit the impact of this decision by making it clear that your handbooks are general statements of policy and not definitive offers. You can also make it clear in that language by saying this is not a contract. It's not intended to be a contract. It's not intended to be an offer. This is just a general statement of policy. Nevertheless, these handbooks are a potential area for trouble. So our first element, if we're potentially getting into trouble as an employer, is our handbook containing one of these specific offers, communication of that offer to the employee, acceptance of that offer, and consideration. That just means so the traditional sort of contract analysis is offer, acceptance, consideration. That just means that the courts are not going to impose penalties on somebody for a promise without more. There has to be some sort of additional thing, consideration, that is to indicate the promise is a serious one, and to bind people to it. Now, in employment cases, traditionally 2, 3, and 4 are fairly straightforward. In this case, the consideration from the employee's side is employment services. I have come to take your job. I've started to work for you. That's consideration, generally speaking. Now, communication, of course, when you're handing somebody a handbook, that is potentially communicating this offer to the employee, and then them accepting and coming to work is potentially acceptance. So oftentimes, where you're going to end up fighting on this, if this is a problem that you're potentially going to run into, is going to be on that first element. But of course, as with any other contract, a contract does not have to be, a contract for employment does not have to be in writing. You can potentially create an oral contract if you're doing these things accidentally. Same elements broadly, but courts do tend to scrutinize these a lot more carefully, just because, of course, the potential for abuse in this doctrine is fairly ripe. All right. So the next big category of limitation comes to us from tort law. And in this case, you can potentially create some serious problems for yourself if the discharge is handled in a way that amounts to a tort, that is a form of personal injury. So in Minnesota, there are torts like fraud, there are torts like defamation, there are torts like the intentional infliction of emotional distress, and discharge of an employee can, under certain circumstances, at least in principle, create liability in the employer on these theories. So that's a potential limitation on discharge. Then, of course, the last one that we talked about is public policy limitations. So we were talking about the 1980s as a particularly fruitful period for jurisprudence in this area, and this is no exception. So in 1987, Minnesota Supreme Court recognizes what it characterizes as a public policy exception to the common law version of employment at will. And that comes to us from Phipps versus Clark Oil and Refining Corporation. So in this case, we have an employee who was directed to dispense leaded gasoline into an automobile equipped to receive only unleaded gasoline. He says no. He says, no, that's illegal. I can't do that. And he's fired for not doing that. So the Court of Appeals says that's not okay. Termination contravened a clear mandate of public policy. And then the Supreme Court affirms. Now, this is not unlimited. As with everything, this has been cabined to a certain extent. But in general, what we're talking about is the at-will employee has to prove that at the time refused, excuse me, I can talk really, I can. At the time they refused to participate in the action. They have to have already formed a good faith belief that the practice was illegal. So it doesn't count if you refuse to do it and then later you find out it's illegal. We have Eighth Circuit precedent saying that. If you believe it at the time and that's the reason that you refuse to do it, then you're potentially within the ambit of this doctrine. Now, because of course we are public employers, there are potentially additional limitations on us because of course we are governments, right? And so things like the First Amendment, things like the 14th Amendment potentially impact this area as well. And if, quite frankly, if there's interest, I would love to delve into the specific weird ways in which that impacts us. Particularly, but given the sort of questions that I had been seeing lately, I thought it might be a good idea to just do the 10,000-foot overview of at-will employment in general, and so that's kind of what I was thinking here.